Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
Today I presented oral arguments in the ObamaCare case, Liberty University versus Geithner, at the Federal Court of Appeals in Virginia. And other developments have occurred recently in the ObamaCare case in another case. We'll talk about it today on Faith and Freedom. Hi, I'm Matt Staver, founder and chairman of Liberty Counsel. We're going to be talking today about ObamaCare with Matt Barber, vice president of Liberty Counsel Action. And significant developments have occurred. In addition to the oral argument, the Obama administration has recently withdrawn its appeal in the Tyndall House Publishers case, meaning that the injunction in that case will stand. Now, this is a significant development, Matt, and of course, now after the oral argument, Liberty Counsel, we've been fighting this now for a couple of years, since the very day it was signed into law in 2010. We're now going to be waiting for a decision at the Court of Appeals, but other significant developments, I think, have happened that actually help our case.
Yeah, you have to wonder a little bit if the Obama administration isn't second-guessing as well, whether they've pushed it a little bit too far with the HHS mandate and they're trying to pick their battles here. Clearly, it's unconstitutional. You argued that point today, that it is obviously unconstitutional to compel any business, any small business with whether they have Christian business owners or not, but certainly a large Christian institution like Liberty University, it's clearly unconstitutional to compel them to violate their conscience by providing abortifacients and so forth. So I hope that the Obama administration will back off on this. We'll see.
Well, you remember the Tyndall House Publishers
Right.
case. The Obama administration were sued under the HHS mandate. They said that they did not want to provide this contraception, sterilization, abortifacients, or abortion-inducing drugs. They ultimately got an injunction by the federal court against the implementation of that. But the Obama administration took the position that Tyndall House Publishers is not religious enough. Even though it's a foundation and even though it's part of the Tyndall Publishing organization and it publishes religious books and Bibles, it's not religious enough. So the Obama administration appealed that to the Court of Appeals, and just a few days ago, they withdrew their appeal. Significant change. They've stopped the appeal, and that means that this injunction, the temporary injunction while the case is moving forward, is in effect, meaning that at least as it relates to Tyndall House, the HHS mandate is not going to apply against that entity.
And of course, if you're going to arbitrarily, who is the arbiter of what is religious enough? The First Amendment, last time I checked, the First Amendment doesn't just apply to an organization that reaches some arbitrary threshold of being religious enough that the federal government gets to determine. Last time I checked, the First Amendment covers everybody, every single individual, and a part and parcel of the First Amendment is the freedom of religious expression, and inherent within that is the right not to be forced by an overbearing federal government to violate central tenets of your faith. And so, clearly any individual, whether or not they're officially stamped a Christian or religious organization, any business owner of any company who has a conscience objection to being compelled to provide abortion services, whether it's through abortifacients or surgical abortion, anybody is covered by the First Amendment and should be able to opt out of that, essentially.
Well, this is good news for our Liberty University versus Geithner case, a case that Liberty Counsel filed on behalf of Liberty University and two private individuals on March 23, 2010, the very day that it was signed into law. And I just now completed oral arguments at the Court of Appeals for the second time. This is a case that I argued at the Court of Appeals, and now we're back because the Supreme Court of the United States directed the Court of Appeals to hear unresolved issues. Those unresolved and unaddressed issues were presented at the court today, and we'll ultimately get a ruling on this sometime later this year. And then from there, whichever side loses, we'll ask the United States Supreme Court to get involved. So this case is back on a track to the U.S. Supreme Court. But the fact that the Obama administration, on one of our claims, which one of our claims includes this HHS mandate, that you can't force religious employers like Liberty University to fund abortion. They've dropped their defense on that. They've dropped their appeal, I think is significant.
Yeah.
And it's interesting timing because it came just a few days before our Liberty University versus Geithner oral argument.
Yeah, is that writing on the wall? I think it is. And, your arguments today made that very point. They're backing off. I think the writing is on the wall that bolsters our arguments. And I can't overstate the significance of the arguments that you had today. In our case in general, Liberty University v. Geithner, is it not the last best chance to completely derail this Obamacare monstrosity?
It is, because there's about 50 other cases that have been filed more recently against the HHS mandate. It's on behalf of religious employers, for-profit as well as not-for-profit. But it's focused on that narrow issue of the forced funding of the abortion, drugs, and contraception. Now, if you win on that, essentially what you'd get is those employers get opted out, but Obamacare stays in existence. But it's the religious employers that get, obviously, the relief. Our case includes that. But our case also includes other things that would knock out the entirety of Obamacare. We have a challenge to the entire employer mandate, that it's unconstitutional in its entirety. And we also have a challenge to the fact that if, in fact, as the Supreme Court said, that the individual mandate is a tax, well, then it violates the origination clause because it originated in the Senate, not the House, and the Constitution requires it to originate in the House, not the Senate, and for good reason. If you're going to be taxed, you need to have representation. And the best way to have representation is the people that are closest to you, which is the House members, not the Senate, which represents the broader state constituency.
Well, and that was done through a series of smoke and mirrors. Look over here. Here's what we're doing. They took a House bill with a House number that had absolutely nothing to do with Obamacare, gutted it completely, and then just packed the Senate bill. And that's what they went with. Clearly, the entire thing originated in the Senate, which violates the origination clause. I'm hoping that Justice Roberts will be consistent now. If he has said that it's a tax. It's clearly a tax, and therefore must originate in the House. Therefore, they're going to have to wipe the whole thing away and start anew.
And even in the case, the NFIB case that held the individual mandate as a tax, it says that they're holding it up as a tax. It could be construed as a tax. I don't think that's correct, but that's what they said. And they said, but it has to also comply with any other law regarding taxes. And they didn't address the origination clause. Our case brings that up. Ginsburg, in her dissent, with regards to the Commerce Clause provision, where the majority didn't think the Commerce Clause supported it and she thinks it did. She said whether it's Commerce Clause or a tax, it could still collide with other constitutional rights. And she specifically mentions free exercise of religion.
Wow.
So, our case has all these components. The entirety of the employer mandate is unconstitutional for a number of reasons. I won't go into all those details. The individual mandate also forces people to fund abortion. So the individual mandate and the employer mandate violate religious free exercise because even though you have those provisions, even though if they're authorized by the Constitution, if they collide with another constitutional right or statutory right, they fall. And then, of course, if indeed it is a tax, then it violates the origination clause. So we've got arguments that are the broadest of any case in existence that could actually torpedo the entire law. It's the best case to turn away Obamacare for good.
Yeah, I think the word for it's the most comprehensive case. We have managed to connect all of the dots on all of the varying arguments together in one package, and we have advanced further than any other case with that package. The next step at this point, if either way the Fourth Circuit goes, we'll appeal. The government will appeal. Either way, it goes back to the United States Supreme Court, correct?
Yeah, that's the next step, all the way back to the U.S. Supreme Court. So no matter what the Court of Appeals does, as important as it is, the final word is going to be the United States Supreme Court. So keep this case in prayers. We thank you for your prayers. We actually solicited individuals to pray for this case, and just because the argument is over does not mean that the prayers are over, because now we're into the writing phase, and we ask that you continue to pray. You can go to libertycounsel.com, libertycounsel.com, COUNSEL, to sign up to be someone who prayed for this case. We actually have over 100,000 people that are coming together around the country signing, saying that they will pray for this Obamacare case for Liberty Counsel. You can also go to our website, libertycounsel.com, to sign other petitions that are available on a wide variety of issues as well. And you can also go to our other website, our main one, lc.org, where you can make an online credit card contribution to help support this and other cases as Liberty Counsel continues to advance religious freedom, the sanctity of human life, and the family through litigation, education, and through public policy. Again, that website is lc.org, lc.org.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.